In this video, I'm going to reveal the top 5 defenses to Florida breach of contract lawsuits that can not only save your business millions of dollars, but potentially turn the tables on the party suing you. I'll show you 2 shocking multi-million-dollar cases where these defenses completely change the outcome, and by the end, you'll understand exactly how to spot these opportunities before they cost you everything or save you a fortune. I'm Santiago Cueto, board-certified international business law expert and best-selling author. And in my nearly 30 years of defending companies against breach of contract claims, I've discovered that the difference between financial ruin and complete victory often comes down to understanding the 5 most powerful defenses available under Florida law. The first and often most powerful defense in Florida is impossibility of performance or frustration of purpose. This isn't just about things becoming difficult or expensive. Florida courts require true impossibility or circumstances that completely destroy the fundamental purpose of the contract. Impossibility occurs when performance becomes objectively impossible due to circumstances between either party's control. Think natural disasters, government regulation, or the destruction of something essential to the contract. But here's where Florida law gets specific. The impossibility must have been unforeseeable when the contract was signed. Frustration of purpose is subtly different but equally powerful. This applies when the fundamental reason for entering the contract is destroyed, even if performance is technically still possible. The classic example is renting a venue for an outdoor festival that gets permanently banned by a new city ordinance. You can still use the venue, but not for its intended purpose. Florida courts are particularly strict about these defenses because they don't want parties escaping contracts simply because they've become unprofitable. The key is proving that the changed circumstances were truly unforeseeable and that they strike at the very heart of what the contract was meant to accomplish. The second defense attacks the very foundation of contract formation: consideration. In Florida, every valid contract requires both parties give up something of legal value. Without mutual consideration, you don't have a contract at all, just an unenforceable promise. The defense is particularly powerful when dealing with illusory promises, where one party appears to commit to something but actually retains complete discretion. For example, a contract that says Company A will purchase widgets from Company B at Company A's sole discretion isn't really a contract because Company A hasn't actually promised to do anything. Florida courts also scrutinize agreements where the consideration is grossly inadequate or one party's obligations are so vague that they're essentially meaningless. The key is showing that what appeared to be mutual obligations were actually one-sided commitments that don't create a legally binding agreement. Now, the third defense leverages the other party's own conduct against them through waiver and estoppel. Now, waiver occurs when a party voluntarily gives up their right to enforce a particular contract term through their words or actions. Estoppel prevents a party from enforcing contract terms when their previous conduct led you to reasonably rely on their apparent waiver. In Florida, these defenses are particularly powerful because courts recognize that business relationships often involve informal modifications and accommodations that aren't reflected in the written contract. If the other party has consistently accepted late payments, waived certain requirements, or otherwise acted inconsistently with the strict terms of the agreement, they may have waived their right to suddenly enforce those terms. The key is documenting the other party's conduct and showing a pattern of behavior that demonstrates their intent to waive enforcement. Florida courts look for clear, unequivocal conduct that will lead a reasonable person to believe the other party was giving up their contractual rights. Now, the fourth defense focuses on conditions precedent, which are events that must occur before a party's obligation to perform kicks in. If these conditions aren't met, the other party has no right to demand performance and therefore cannot claim a breach. Florida law distinguishes between conditions precedent and covenants. A condition precedent must be satisfied before any obligation arises, while a covenant is a promise that creates immediate obligations. Understanding this distinction can be the difference between owing millions in damages and owing nothing at all. This defense is particularly powerful in complex commercial arrangements that involve multiple phases, approvals, or dependencies. If the party suing you fail to satisfy their own conditions precedent, they cannot demand that you perform your obligations under the contract. Let me tell you about a case that perfectly demonstrates how these defenses can save companies from devastating losses. A Jacksonville-based shipping company had entered into a 5-year exclusive logistics contract with a major retailer worth over $200 million in total revenue. However, 2 years in, the retailer filed a $68 million breach of contract lawsuit claiming that the shipping company failed to meet delivery timeframes and customer service standards. The shipping company's legal team discovered that the contract contained a condition precedent requiring the retailer to provide updated inventory management software essential for meeting the performance standards, but the retailer had never provided the software despite multiple requests. The shipping company argued that the retailer's failure to satisfy the condition precedent meant that the performance obligations were never triggered, and also claimed waiver and estoppel since the retailer had demanded performance without providing the necessary tools. The Florida court agreed on both counts, ruling that the software integration was a condition precedent and that the retailer had waived the right to claim breach by demanding impossible performance. Not only was the $68 million lawsuit dismissed, but the shipping company successfully countersued, and the retailer ultimately paid $12 million in damages while being required to either provide the software or release the shipping company from the exclusive arrangement. This case demonstrates how understanding contract conditions can completely reverse the outcome of major litigation. Now, if you're starting to see how these defenses could potentially save your business millions of litigation, and you want to make sure you never miss insights that could protect your company from costly legal disasters, hit that like button right now and subscribe to my channel so you'll be the first to know when I break down more of these game-changing legal strategies. Trust me, the next case shows how even a seemingly hopeless situations can be turned into a massive victory. Our second case involves an even more dramatic reversal that turned a devastating lawsuit into a counterclaim windfall. A Fort Lauderdale real estate development company had signed a contract to purchase prime waterfront property for $85 million with extensive due diligence periods and multiple conditions precedent. However, 6 months later, when the developer had spent over $4 million on studies and approvals, the property owner filed a breach of contract lawsuit demanding forfeiture of the $10 million deposit plus additional damages. The developer's legal team discovered that the property owner had been actively marketing the property to other potential buyers while the developer was performing due diligence and had actually accepted a backup offer at a higher price. The developer's defense combined multiple strategies, arguing frustration of purpose due to the seller's misconduct, waiver of timing requirements by the seller's acceptance of previous extensions, and anticipatory breach based on the seller's marketing to other buyers. The case took an unexpected turn when the investigation revealed the seller had been aware of significant environmental issues that hadn't been disclosed and had been working with the backup buyer to avoid expensive environmental remediation requirements. The Florida court not only dismissed the breach of contract claim, but allowed the developer's counterclaim for fraud and intentional interference, resulting in the developer being awarded their $4 million in due diligence costs, return of their $10 million deposit, and an additional $31 million in punitive damages. This case demonstrates how thorough investigation and strategic use of multiple defenses can not only defeat a breach of claim lawsuit, but create opportunities for substantial recovery. Now, the fifth defense addresses situations where the contract itself or the circumstance of its formation were fundamentally unfair. Unconscionability in Florida requires both procedural and substantive elements. Procedural unconscionability involves unfair bargaining processes, such as high-pressure tactics, lack of opportunity to read or understand terms, or significant disparities in bargaining power. Substantive unconscionability focuses on terms that are so one-sided that they shock the conscience. Economic duress is a related but distinct offense that applies when one party was forced to agree to unfavorable terms due to financial pressure created by the other party's wrongful conduct. Florida courts recognize that in business relationships, one party sometimes has the power to create financial emergencies that force the other party into disadvantageous agreements. The key to these defenses is showing that the party claiming breach took advantage of circumstances that made truly voluntary agreement impossible. This can involve threatening to breach existing contracts unless new terms are accepted, or exploiting financial distress that the other party helped create. Understanding these defenses isn't just about escaping from bad contracts. It's about recognizing opportunities and structuring your agreements to avoid giving others these same advantages. When you're negotiating contracts, consider how these defenses might apply and build protections into your agreements accordingly. Document everything, especially when circumstances change or when the other party requests modifications or extensions. These records can be crucial evidence if you later need to prove waiver, estoppel, or change circumstances that support your defenses. The reality of Florida breach of contract law is that the party who best understands these defenses often wins, regardless of who technically breached first. The two cases we examined today show how companies turn potential disasters into victories worth tens of millions of dollars by understanding and properly asserting these defenses. As someone who's used these strategies to save countless businesses from devastating lawsuits, I can tell you that knowledge of these defenses is often more valuable than the contracts themselves. They represent your insurance policy against the unexpected and your opportunity to turn the tables when others try to take advantage. Now, if this breakdown of Florida's top contract defenses gave you insight that could protect or benefit your businesses, I'd really appreciate a like on this video. It helps other business owners find these crucial legal strategies. And make sure to subscribe to my channel for more insights that can save your company millions in legal battles. Because in contract law, the best offense is often a well-prepared defense. See you in the next one.